All right, the second case is from Allen County. It is number 128044, entitled William Monroe Trester versus Wayne Vanderford. Who do we have here for the appellant?
May it please the court, judges, Jacob Knight appears on behalf of the appellant, William Monroe Trester.
And the appellee?
The appellee appears through counsel Mark Warner.
Mr. Knight, whenever you're ready, and do you wish to reserve any time for rebuttal?
I would request 3 minutes for rebuttal, Judge.
That is granted.
Judges, this is a adverse possession case, and as you're well aware, there's certain elements that have to be proven by the claimant for an adverse possession claim. Open, exclusive, and continuous possession for a period of 15 years that is either under a claim knowingly adverse or under a belief of ownership. The case law proves out that that belief of ownership has to be a good faith belief. Here, the claimant, Mr. Vanderford, was only claiming adverse possession under a belief of ownership. There was no knowingly adverse claim that was argued. We believe the trial court got this wrong because there's not substantial competent evidence in the record that supports the judge's conclusion that Mr. Vanderford proved by clear and convincing evidence each of those elements that I just listed.
Tell me, there was a deed, the record reflects there was a deed prepared conveying this property to Mr. Vanderford.
Mr. Vanderford testified that he got this deed.
And it was filed at the Allen County Register of Deeds.
Allegedly.
And pulled back.
Allegedly. Number one, that story is not really believable because...
The court made a finding that that happened.
Well, there was no evidence that was really presented on that point. Mr. Vanderford testified that this is what happened. His story was that he had an agreement with John and Millie Trester, William Monroe Trester's father and stepmother. He said he had an agreement from them to purchase this property. When asked about this agreement on direct examination, he said that there was no agreed purchase price. And then just a couple minutes later, during examination, he said, well, I paid $7,000 for this property, $350 a month. He said he began making these payments in November of '97, and that he made the final payment in April of 2001. And as I pointed out in the brief, the math simply does not work out for that payment scheme. He also claimed that he made an $800 balloon payment. For not having an agreement, he was pretty specific about what this purchase price was and how much he paid. Yet the math simply didn't add up. If he had made $350 payments for every month from November '97 to April 2001, then he would have paid over $14,000.
So the record also reflects that your client admitted that he paid for the land.
My client testified that he believed that his father had refunded some money. That was the story he had been told. For the other point I was going to make regarding this deed that was allegedly filed.
But doesn't the acknowledgement that he paid money support the fact that there was an agreement to purchase this land?
Well, we don't know what the money was paid for. My client never admitted that there was an agreement. He testified that he didn't know whether there was an agreement. It could have been a lease arrangement. We don't know. There was no evidence of this deed that was allegedly prepared and withdrawn.
Well, the court in its journal entry said, then later inconsistently claimed that his dad told him that he refunded the purchase price to the defendant. That's a specific finding by the court. How do we ignore that?
I would just I'm not saying ignore that finding. I'm saying the other evidence that was presented as a whole, when reviewing the entire record, does not support the rest of the conclusions reached by the court. That one point about whether there was an agreement or not, or whether there was money paid or refunded, doesn't prove the rest of the elements of open, exclusive, and continuous use. It may have been some foundation for a belief in ownership, but that's it. And the other point I was going to make regarding this story about an agreement was the timing of everything else. Because Mr. Vanderford also testified that after he made this final payment, or supposedly made this final payment in April 2001, he asked John and Millie Trester several times for a deed to this property. He had to ask them several times. Then one day they just show up out of the blue, and they bring a piece of paper, and they sit down with, and John Trester or Millie Trester sit down with Mr. Vanderford and his ex-wife, and they type out this deed. And they all go together to the Register of Deeds office to record it. Then a day or two later, all of a sudden John Trester's coming over to his house, to Mr. Vanderford's house, all upset, saying that there was an issue with the deed, he's withdrawing it. And then apparently a day or two later, the sheriff is looking into it. The sheriff's department sends a letter to Mr. Vanderford saying that there's no fraud that was found. And then he asks again for a deed. Apparently the first deed was supposedly withdrawn because there was 2 legal descriptions on there, one of which was not for the property, subject property. He asked for another deed. Says he asked numerous times, never got it. Then he goes to local title company and has an affidavit of equitable interest prepared. That's recorded on April 3rd. He says he made the final payment April 2001, and all this other stuff that happened with the Tresters took place in 2 days. He asked for a deed after the final payment. It was recorded, withdrawn, and then he asked for a new deed. And all of that happened before he filed this affidavit of equitable interest. The timing of that doesn't work out. That's a period of 2 days. It's just not believable.
Well, did he say he paid for the land on April 1, or that he had paid it off in 2001?
He says he paid it off April 2001. He didn't say April 1st, but April 2001. And that was in, I believe, in his counterclaim as well. And regardless of all of that story, there was very little evidence presented that showed that Mr. Vanderford was open with his alleged occupancy of this property. The neighbor next door, Mr. Bigelow, testified that he could see into the property and see to the back of the property where at one point in time in 2023, Mr. Vanderford did put a trailer, but he didn't see it there prior to that time. And he'd only seen Mr. Vanderford or his family members out on the property a handful of times in the prior 25, 26 years.
But what about the affidavit of equitable interest? Even if it is void after a certain period of time, wouldn't that have put the opposing party on notice that he claimed to have owned it?
As I argued in the brief, Judge, I believe John and Millie Trester could have reasonably disregarded that affidavit at that time. Because as the statute provides, it is and should be void after 30 days. And the reason for that is that I could just go file an affidavit of equitable interest saying I'm claiming an interest in your property. If I don't have something that supports that, such as a written agreement for me to buy that property from you, then what's to protect you as the legal title holder? The burden's not on you to come file a quiet title to get rid of some nuisance, some random person filing an affidavit of equitable interest on your property. The burden's on me to be proactive in asserting my legal rights to that property. And regardless of that affidavit, he still has to prove that he was open with his use. And there was no testimony that Mr. Vanderford fenced the property, gated the property, put up signage of any kind.
There was evidence he painted the post purple, which means no hunting.
He stated that at one point in time. He wasn't clear when he did that. The Bakers, who went out in 2023, January and February, indicated they saw no signs of that nature. So it's unclear when Mr. Vanderford did that. It could have been when he did everything else more openly, whenever he started homesteading, as Mr. Bigelow testified to, which was Memorial Day 2023, which had been after the time this suit was even filed. This suit was filed, so then he starts to take more open actions. As far as the exclusive piece, there was testimony that John Trester had given permission to Bud Jackson to go out and hunt all the way up to at least 2005, and he'd never seen any activity or signs of activity of anyone else. And that's important because one of the main activities that Mr. Vanderford and his family members testified to was hunting. We don't know exactly what they were hunting for, but I'm a hunter myself. I know if you're hunting for deer specifically, that's going to be in the fall and the winter time, the same time periods that Bud Jackson testified to being out there and not seeing anyone.
But wasn't there also neighbor testimony that they had heard guns being shot there and motor vehicles driving?
They'd heard some things. Didn't exactly say who that was. He'd seen, the neighbor, Galen Bigelow, testified that he'd seen numerous people come and go through the years. He wasn't sure who the owner was. There was also practical limitations that I raised in the brief, given that Mr. Vanderford was wheelchair bound at trial. And there was testimony from his family members that he's been disabled for a long time. So squaring that with the other testimony that this was a thick, brushy property in rural Allen County, difficult to access for two able-bodied men, Scott and Matthew Baker, in January of 23, they had to cut their way onto the property with chainsaws and other brush clearing equipment. Yet we have Wayne Vanderford, who's wheelchair bound, who's apparently going onto the property and having gardens the size of the Allen County courtroom, 3 or 4 of them, he said. He's also, excuse me, planting trees, hunting, putting campers out there. How is he doing all of this himself?
You're going into your rebuttal time at this point.
Let me ask you one quick question. The evidence also reflected that he started paying the property taxes in 1997 or 1998, and that Mrs. Trester also went with him to the Allen County Courthouse to help him pay the taxes for the first time. Do you dispute that?
Well, I certainly do dispute that, but we don't really have a way to really refute it because, unfortunately, Miss Millie Trester is deceased, as is John Trester. So really, the only way the only testimony on that was Wayne Vanderford's point.
All right. Did you go to the Register of Deeds office and verify who made the payments on the real estate taxes?
Unfortunately, I was not trial counsel on this, Judge. So
the evidence we have is that it was paid for by Mr. Vanderford.
the tax records did show payments through the years by Mr. Vanderford. But as Mr. Trester, William Monroe Trester testified to, there was not a 15-year period where Wayne Vanderford paid the property taxes for a consecutive 15 years. It was interrupted by Millie Trester and John Trester, and then later on, William Monroe Trester.
Let me ask you another quick question as well, and I know that it's not your burden in this case, but did your client ever take any actions to try to kick Mr. Vanderford out or to protest his being there?
As soon as my client, William Monroe Trester, became aware of Mr. Vanderford at all, he initiated this lawsuit. That's it. He acquired the property in 2020 from Millie Trester. They had went out to the property shortly before that. It didn't look like there had been anything done to the property. It was overgrown. He testified to this. So he had no reason to really take any action regarding Mr. Vanderford until he sold the property to, I don't recall if it was Scott Baker or Matthew Baker, one of the two Bakers. And then, after then taking a deed in to record it, then discovers there's this affidavit of equitable interest there. He refunds the money back to Mr. Baker and then initiates this suit.
Okay, thank you.
Please, court, let me address that issue first. John Trester received title of the property from Millie Trester in 2020. He initiated the lawsuit in 2023. So there was a 3-year gap where nothing was done after John Trester took title of the property. The prior question about the property tax payments, Mr. Vanderford started paying the property taxes in 1997 when he began paying for the purchase of the property. Only 1 year, in 2010, Millie Trester paid the taxes. But then then Wayne Vanderford paid up to that year, and then for subsequent years until 2020, when John Trester took title, wouldn't let Mr. Vanderford pay the taxes. So except for 1 year's interruption, Mr. Vanderford paid the property taxes each and every year.
Wait, you're confusing John and William?
Sorry.
Am I correct?
John Trester, the son, who took title in 2020 from his parents.
Oh, I thought his name's William.
John Trester's the son.
William
William John Trester is what his full name is.
This says William Monroe.
I
just want to make
I'm
sure.
jumping in there, sorry. The son, the appellant, is the son of John Trester, the father. I'm
Right.
getting
He
my
started
names
paying the taxes in
in 2020, correct. But up to that point, Wayne Vanderford paid the taxes from 1997 to 2020 with 1 year's interruption in 2010. Sorry, didn't mean to confuse you on
Oh,
that.
that's all right.
So
That's why we're here, is to get
Yeah.
this.
And that was with the knowledge of the parents of the current owner, John and Millie Trester. So let me start out with a couple of general comments, and that is that whether title is acquired by adverse possession is a question of fact to be determined by the trier of fact, and that is the trial court. The resolution of such factual questions is binding on appeal if it's based upon substantial competent evidence. It's our position that there was substantial competent evidence presented at trial to support the trial court's decision. Substantial competent evidence is the facts which can be determined from the issue, reasonably determined. Specifically stated, this court will not weigh the evidence and pass on the credibility of the witnesses. I cited the cases in my brief. What the appellant is asking you to do is just that, is to review the evidence. Their comments are, we don't believe the credibility of the witnesses, we think there's contrary evidence, but it was a trial judge at trial that listened to the witnesses, that looked at the evidence that was presented, and made a decision. And now they're wanting to supersede that on appeal. And that's not what we should be doing here.
Did the district court make a credibility finding in favor of your client at one point about the purchase price? I
believe they did. I mean, they found that there was a binding contract that was paid off, that my client purchased it. They found that there was a deed that was filed. That was never contradicted by the other testimony, by the appellant's witnesses. They found that that deed was withdrawn. Now, we don't know how that happened. Small towns, that stuff happens, unfortunately.
Are you talking about removing the deed?
The removing of the deed.
Have you ever heard of that before?
No, sir, I have not, and I do a lot of real estate practice.
I've been practicing law for a long time, and I've never heard of it.
And of course, how can you prove a negative? So we could not find any evidence of the recording of that deed. And that is why the affidavit of equitable interest was recorded by my client. And there was testimony, direct testimony by the appellant's side at trial that that John Trester had actual knowledge of the affidavit of equitable interest being filed. So there was no question that there was no actual knowledge of the filing of that document in 2001. Now, we did not move on the affidavit for ownership, but for knowledge of open ownership, of a belief of ownership, based upon the payment of the purchase price. So that is fulfilling one of the tenets of the adverse possession to statute 6503, and the trial court found that. That was meeting one of the criteria. The court found that there was an oral agreement to purchase the property. John Trester told Wayne Vanderford, go out and enjoy the property, use the property, in '97, when the contract was first entered into. Wayne Vanderford testified, unrefuted. They made go-kart trails and other trails out there, game trails, planted fruit trees, they hunted, they built temporary and permanent structures, several different trailers, and then he ultimately lived in a camper trailer out there, put up solar panels, built habitat and feeding stations, resided on the property for most of the year as much as he could, all unrefuted, not contradicted. And I mentioned paying the property taxes. Paid the purchase property off in 2001, and talked about the math not adding up, but the court found it was a completed transaction. And why would John Trester have signed a deed over to Wayne Vanderford if he hadn't paid off the purchase price? Now, he pulled it back, but it was because of there being two legal descriptions on the property, on the deed, not just this 7.3 acre tract. So it had nothing to do with the completion of the purchase price. So it was a completed transaction. There was never a time between when John and Millie Trester owned it or when the appellant owned it where they sent notice to my clients saying, get off the property. You're not in possession. Vacate it. Leave it. They never sent the sheriff off to move them off. There was never an attempt to assert ownership and control by the appellants or by the appellant's predecessors, which is a critical factor in the ownership and control. Regarding the next door neighbor, he testified that over the years, and not just in 2023, he saw people over there, my clients over there, and let's talk about what he saw. He testified on cross-examination by me that he has buildings and structures at the front of his property that restricts his view. His view is limited to the back part of the property. My client testified that over the years he moved around. Some years with his camper trailer, he'd be at the back of the property. Some years he'd be toward the front. So Bigelow, the next door neighbor, would not see it every year. He'd see people some years at the back. Some years he wouldn't see them at all, but he heard them over there. And let's talk about my client. He's not completely wheelchair bound. He rides a four-wheeler, he drives a front end loader, he maintains the property, and he has these 2 or 3 or 4 large gardens. So he is capable of getting around the property. But he doesn't go show signs and he doesn't do stuff because it's an overgrown lot. It is. But he has people, he has nephews that hunt the property. His son has an extensive beekeeping operation. You don't hide the bee hives. They're big and yellow and orange and they're all over the place. So there's a lot of obvious uses of the property. So the trial court concluded that they met the criteria for an open possession of the property. Over that 25 years, they did all the things that I've already mentioned. The witnesses that were presented by the appellant, by and large, had only been on the property intermittently in a limited period of time. That did not contradict by the trial court the testimony of the appellee. And I think that was the conclusion of the trial court in listening to all the witnesses and looking at the evidence of all the improvements that were done by the appellee. And I would mention that under Tucker v. Hanley and Wright v. Sook, it says that improvements or lack thereof do not speak to possession. But there were improvements and it shows possession. And possession was also proved by the affidavit of equitable interest. It's interesting to note also that the trial court in the memorandum decision mentioned that in the findings of fact and conclusions of law filed by the appellant didn't even touch on the affidavit of equitable interest. Didn't mention it in their findings of fact and conclusions of law. I would submit that they conceded that issue when they filed their findings of fact and conclusions of law. They knew it was there. They couldn't do anything about it, so they didn't address it. What about exclusive possession? Crone v. Nuss says exclusivity is relative to the type and nature of the property and the surrounding circumstances. So my client, the appellee, says he lives out there most of the year. They use it. They hunt on it. They keep bees on it. They hunt mushrooms on it. They do the things you do with a rural hunting property. The appellant says, well, there's a few times a guy hunted on it, and there's a few times a couple other people went out to look at it when they were going to buy it. So I would submit that the exclusive component of the adverse possession statute was met clearly by my client, and that was a finding made by the trial court. A few random people going out there is not going to defeat the exclusive claim, and there's ample cases on that. Incidental context does not defeat exclusive possession. So continuous, again, clear testimony at trial that from 1997 forward, the appellee used, enjoyed, and possessed the property uninterrupted by the appellant. There was no evidence presented at trial to the contrary of that, other than 1 year, 2010, when John and Millie Trester paid the taxes. That's it. So again, I would say that it was continuous possession. So it's our possession that all of the criteria, the open, exclusive, continuous components with a belief in ownership through the affidavit of equitable interest, all the components were met by the appellee to meet the criteria that there was substantial competent evidence presented at trial, that the trial court did not abuse its discretion in making those findings, and that the decision of the trial court should be upheld. Any more questions I could address for you?
Apparently not. Thank you, counsel.
Thank you.
Lot to address there. See if I can hit it all.
Well, you've got 3 minutes.
30 minutes, all right.
No,
Oh, wait,
three.
I'll hit the standard of review first. Obviously, there's no reweighing of evidence, but we're asking you to look at the record as a whole. And to be honest, there has to be a little bit of a reweighing of evidence. If you have to look at the evidence, the record as a whole, to determine if there's substantial competent evidence there to show that the claimant proved by clear and convincing evidence. How can you make those determinations without sort of reweighing a little bit? Regardless, there were presumptions that could have been made here based on the testimony. All we had regarding some of these things was Wayne Vanderford's testimony. All we had regarding the agreement that you asked about was Wayne Vanderford's testimony. That's it. There was no documentary evidence of it. There was no documentary evidence of this deed that was allegedly prepared and withdrawn. And I had the same question you did, Judge Schroeder. I've never heard of a deed being withdrawn. Usually you have to file something else with the register of deeds saying it's revoked or something else overcoming it, superseding it.
What if the judge finds that person's testimony credible? Why isn't that enough?
It may be credible that there was something there, but I think that finding is in error because we're trying to show that if you look at the rest of the evidence, that there's no way that that's clear or competent evidence because of the
judge made a finding that he paid for the land. We're bound by that finding, are we not?
I don't believe you can look at that and say that that's enough.
But the court made a determination on his credibility that he paid for the land between 1997 and 2001, whenever it was. Aren't we bound by that?
I don't believe you are because if you look at the evidence as a whole, it doesn't support that finding. But even if you're bound by that finding, looking at the rest of the evidence, as far as open, exclusive, and continuous, the open requirement, Mr. Warner argued at trial that was satisfied by the affidavit of equitable interest. That's a novel argument, as I pointed out in my brief. There's no case law out there finding that an affidavit of equitable interest can satisfy the open requirement. All the case law is that a person has to be open in their actual possession of the property to put the world on notice that they're out there in possession of the property. Here, there was no evidence presented, and Mr. Warner just admitted in his arguments to you guys that Mr. Vanderford was private. He kept the property wooded and brushy. So there was no way for people to know he was out there. And as such, there would have been no way for John and Millie Trester to know he was out there, to then trigger their burden to take some further action to oust him, such as sending him a letter or taking some other affirmative legal action.
What about his paying taxes on it every year?
Thank you. They send him a thank you card at the end of the year.
What about?
I'm not trying to be flip, but
Well, I mean, it is a little bit, but to the extent that he painted the post purple to give hunters notice that they couldn't hunt on it unless they had permission, wouldn't, if Mr. and Mrs. Trester had been out there, they would have seen that and said, well, who's put that on my property?
again, there was no testimony from Mr. Vanderford when that happened. That could have happened after John and Millie Trester were both deceased, after William Monroe Trester became the legal title holder,
And
when
so-
Mr. Vanderford started taking his other actions of showing that he was actually out there of homesteading.
And your evidence of other people being on the property is something that's more recent than in 2000 or 1997 to 2010 or 2015.
Not necessarily. We also had testimony from Dick West, who was a neighbor down the road, who testified in favor of Mr. Trester, that he drove by that property every day or every other day and saw no signs of activity.
You gotta wrap it up in about a minute.
Will do, Judge. So as I mentioned, if Mr. Vanderford would have been more open with his occupancy, that would have then triggered something for the Tresters to have done. The burden did not shift from Mr. Vanderford. He was the one who had to prove by clear and convincing evidence each and every one of those elements. If there were any presumptions that were to have been made by the trial judge, they were to be in favor of Mr. Trester as the legal title holder. That's what the case law shows. There were also some legal errors that are de novo review by the court. First and foremost, by the trial judge saying that the Tresters failed to take any legal action to quiet their title on the property after 2001 for over 15 years. John and Millie failed to enforce their ownership rights to the real estate against Wayne Vanderford for an extended period of time, in excess of the 15-year period. The burden was not on them to do that. The burden was on Wayne Vanderford to be open, exclusive, and continuous with his use and occupancy of that property. The burden was not on them. That's a misapplication of the law to say that the burden was on the Tresters to take affirmative action. And also, the finding that this affidavit of equitable interest satisfies the open requirement without other evidence actually presented by Mr. Vanderford showing his openness. He admits in his testimony and his attorney's closing remarks at the trial, and even here today, that he was he was a private person. He tried to stay out of sight, out of mind. He didn't want people to see him or know he was out there. That's the antithesis of openness. That is the opposite of what our case law provides for. And so, in conclusion, because the record on appeal does not show that there was substantial competent evidence to support the findings that Mr. Vanderford proved by clear and convincing evidence that he was open, exclusive, and continuous in his possession of the subject property for 15 years, this court should reverse the ruling of the trial court and quiet the title of the property in William Monroe Trester.
All right, counsel, thank you very much for your briefs and your arguments. We will get a written opinion out to you just as soon as we possibly can.
Thank you, Judge.
Thank you.
And